So the appeal brief for Victor Mignogna has been filed against Funimation, Monica Rial, Ron Toye, and Jamie Marchi. Let's do a quick recap of the case, assess where we are, and we're going to go through 3 quick sections on the appeal brief as an introduction to what to expect as you're looking at this document. Hang out with me. Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And this is a quick legal update on the VIC Mignogna case. If you like these quick videos, make sure you like and subscribe so you get notified when they come out. Also share and like them, all of that junk that you got to do. Okay. Where are we in the case? I've been asked by a couple people who don't follow the live streams, which you can catch pretty much every weeknight at 11 p.m. Central. There's also a backlog of them, but they are very long. And if you don't have like 3 hours to watch, just follow along with these. It's a little easier, a little less dense. All right. Here's the update on the case where it is. As you probably know, back in April of last year, that would be 2019, VIC filed a lawsuit against Funimation, Jamie Marchi, Monica Rial, and Ron Toye. It was challenged under something called the Texas Citizens Participation Act, in which the defendants get to assert that the plaintiff brought the lawsuit specifically to silence their free speech. Okay, that's the very, very high level overview. There's a lot of material out there about the TCPA and lots of opinions about it, but we're not going to get into it. Basically, they're saying that whatever the plaintiff did here, he didn't show that that his damage overcame their right to free speech. Kind of a summary of that. They were successful in getting the lawsuit dismissed under the TCPA, okay? So at the trial court stage, or I guess technically the pre-trial stage of the trial court, VIC Mignogna did lose on all counts. That's important to know. He lost at the TCPA stage. Now, when you lose on all counts at TCPA, you have the ability to appeal that decision to the Court of Appeals, and it has been appealed to the Second Court of Appeals, which is Tarrant County, Texas, where Fort Worth is. That's where the lawsuit was. That's where the appeals court is. So now it's going to be reviewed by a 3-judge panel. All right, it's 3 judges out of the Texas Court of Appeals, judges for the second district, and they will come in and they will make a 2 out of 3 majority decision, or 3 out of 3 decision on whether or not the ruling at the lower court was the correct ruling. To do that, both sides have to submit briefs. VIC has to submit a brief giving a statement of all of the things that were wrong from his perspective. The other parties get a chance to submit their response to that brief and say why the judge was right. And then VIC gets a reply brief to those if he wants to use it to clarify or counter any factual inaccuracies or legal inaccuracies, or make legal arguments or counter legal arguments that they raised in their reply. All right. So at this point in time, the first step of the appeal has happened, and that is VIC has filed his appeal brief. It's about 50 pages plus an additional 10 pages of table of contents and all of that stuff. What we're going to do in just a second here is look at what the sort of the summary portions of this appeal brief are, so that they can give you a high level look at what the arguments are. All right, we're going to check out the statement of the case, we're going to check out the issues, and then we're going to check out the summary of the argument. We're not going to go through the fact sections or the in-depth stuff on all the arguments in this video. All right, but be watching over the next week, and I will be putting out a video on each section, and then of course we will be getting updates as the other side files their stuff. They have about 30 days to do that, maybe 20. I'm not quite sure on the response date for them, but it is in March. All right. So we'll see their response sometime in March. And they also have a cross appeal that is about the fees. We'll tackle that in a different video. This is just the main bulk of the case. And so I want to put that information in your hands at a very high level. This is Vic's side of the argument for what went wrong at the trial court level. All right. So here we go. Here is the statement of the case. All right, Victor Mignogna sued Funimation Productions LLC, Jamie Marchi, Monica Rial, and Ronald Toye for defamation, conspiracy, tortious interference with both existing contracts and prospective business relations, and as to Funimation Productions LLC only, vicarious liability. Appellees filed motions to dismiss under the Texas Citizens Participation Act. After a hearing, the trial court granted appellees' motions and dismissed all of appellant's claims with prejudice. After a subsequent hearing, the trial court ordered appellant to pay attorney's fees and sanctions. Okay, so just some clarification on the language here. The appellant is Victor Mignogna. The appellees are all of the defendants from the original case. Funimation, Jamie, Monica, and Ronald Toye. Okay, so this kind of lays out what I just said a little bit more concisely. Let's quickly talk about what each of these different causes of action are. Defamation is where you lie about someone to cause to someone else to cause damage to the person you're lying about. So I tell you a lie about Bob, and then that causes damage to Bob. He loses a job, he loses reputation, he loses a contract, something like that. That's defamation. If it's a lie about someone else, then and it causes them damage, defamation. Conspiracy, that's when two or more people, this is not the like, oh, it's a conspiracy that involves the government and all that stuff. No. This is just two or more people working together to do some tortious or injurious act, okay? So in this case, if any two of the defendants, say Monica and Ron, who are not married, so they are separate defendants, right? If they got together and discussed defaming Vic Mignogna and issued some sort of plan and worked in concert to bring about this defamation, that would be conspiracy, okay? So in this suit, all four parties are alleged to have conspired at different points about different things. Okay, but all of them kind of together. Very, very complex web that we weave here. Tortious interference with existing contracts is when I know that person B has a contract, so I talk with person C, okay? No, with person A. Person A and B have a contract together. I'm person C, okay? Person A and B have a contract together. I talk to person A to get them to break their contract with person B. And then they do. All right? Now, there's a whole lot more to it, but that's the basic thing. I have come in and inserted myself into a contract that was valid and prevented the execution of the contract in a way that's not permitted, right? So there's a whole bunch of ways to make it permitted and not. In this case, they're saying that these guys specifically interfered with existing contracts that Vic had with conventions. One of the big ones was KamehaCon, right? KamehaCon had a contract with Vic for Vic to come to appear at the show. Ron and Monica contacted the owner of KamehaCon, told them that criminal charges were coming against Vic and a whole bunch of other stuff that happened to not be true, and then KamehaCon broke off the contract. Now, KamehaCon ended up signing an updated or a new contract with Vic Mignogna that included some new burdens that he had to do. He had to pay for security, he had to move to a different spot, and he had to incur legal costs to get that contract reinstated. So he suffered some damage there. So they're alleging that that interference is improper. Now, tortious interference with prospective business relations is similar, but it involves contracts that are likely to manifest in the future, that a party would reasonably know would manifest in the future. So in this case, it would be that Jamie and Monica and Ron and Funimation all know that Vic goes to these conventions because they're in the industry. The conventions are part of the industry. These guys go to those conventions. They've all been doing it for years. And so they kind of know the workings of it. And they know that certain actions that they take, specifically like lying about certain attributes or actions of Vic Mignogna, would cause him to lose work going into the future. That's the allegation here, that he would lose these contracts that they know have a reasonable chance of manifesting. All right. And then finally, we've got vicarious liability. This is the idea that Funimation, as the employer of Jamie Marchi and Monica Rial, and possibly even Ronald Toye, that's what's alleged in the original complaint, were responsible for the actions that Funimation were responsible for the actions of Jamie Marchi, Monica Rial, and Ronald Toye because of their employer-employment relationship. Now, typically to show vicarious liability, you have to show that the workers were engaged in an activity that relates to their employment or their roles or their duties to the employer. All right. So this has been alleged at this point that Funimation should be responsible for Jamie Marchi, Monica Rial, and Ronald Toye's statements because they were acting basically as agents or employees of Funimation in their campaign of defamation and tortious interference against Vic. All right. So that's what all of those terms mean. Now let's real quick go through the issues presented. This is where you lay out each point of error that you find in the lower court's thing. These are the 8 issues that they want to focus on in this appeal brief. So the first one, the trial court's dismissing appellant's claims against appellees for defamation is reversible error. So the dismissals, these are the easy ones. This is wrong. It should have preserved the claims for defamation, not dismissed them. Same thing with tortious interference with existing contracts, prospective business relations, and vicarious liability and conspiracy. Those are the first 5 points. Those are the 5 major issues in the case, generally speaking, right? That it was reversible error for them to dismiss those things. So what they're saying is that the appeals court should come in and overrule the trial court and say, nope, these counts need to go on to a jury trial. All right, so number 6, the trial court's refusal to consider appellant's second amended petition is reversible error. At the trial court, Judge Chupp decided that he wasn't going to include the second amended petition. Part of the problem with that statement is that he didn't actually strike it. He just said he wasn't going to consider it. So the question is whether or not it was struck effectively. And there's a good argument that he did strike the second amended petition. He did say, I'm not going to consider that. The problem is without actually striking it, he can't not consider it. It is the live pleading unless it's struck. But could a reasonable person come in and say that he struck it based on his language? I mean, sure, you can make that argument. Could a reasonable person argue that he didn't strike it or that the strike was improper? Yes, they can do that too. And that's what Vic's team is doing here. They're going to argue that he either didn't strike it or that the strike that he did was improper under the rules. So the next part, appellees presented legally insufficient or factually insufficient evidence to satisfy their burden under the TCPA, and trial court's finding otherwise is reversible error. When you raise a TCPA issue, when you make a motion to dismiss under the TCPA, it's first the defendant's job to say that the TCPA applies. Now, Vic's team's argument is that they didn't do that adequately. The judge obviously disagreed with them because he ruled that it did apply. But their argument hinges on some pre-hearing motions that they had to strike evidence that they said was either irrelevant, lacked foundation, or was hearsay and therefore inadmissible. If that evidence was inadmissible, then it'd be hard to argue that they made a showing by a preponderance of the evidence that the TCPA even applied. So this is kind of a Hail Mary pass in my opinion, because it says that if they win on this, then they win and they move past the TCPA automatically. But I think the likelihood of winning on that is low because the trial court has to come in and say that the judge abused their discretion in not striking any of this evidence. And that's a hard thing for the appellate court to do, to overrule the trial court, who they give broad discretion on the admissibility of evidence. But that's their argument there. And then number 8, the trial court's ordering appellant to pay appellee's attorney's fees and sanctions is reversible error. Part of winning at TCPA as the defendants, if you win, the plaintiff, in this case Vic, would have to pay some or all, depends on how it goes, of your attorney's fees plus a sanction or a penalty fee in addition, and that sanction needs to be sufficient to deter future activity. So since the defendants won at the TCPA, at the trial court level, the judge awarded them, as he is supposed to, he awarded them fees and costs and sanctions as the statute requires. They're saying it was reversible error because they're saying that the claims shouldn't have been dismissed, so therefore they shouldn't have to fork over the cash for the attorney's fees and sanctions. So that's the issues presented. Now let's check out the quick. We're not going to read this statement of facts because it's pretty long. You can check these out on the streams or in the upcoming videos that will follow this. But here's a summary of the argument. It's very quick, and it kind of lays out some of the stuff I've been saying, but I want you to hear it from their legal team. Trial court committed reversible error by dismissing Vic's claims for defamation, tortious interference with existing contracts, and tortious interference with prospective business relations because Vic presented clear and specific evidence of a prima facie case against all appellees. Prima facie just means that you've given, well, actually, it's going to say it. It's going to say it in just a minute, I think. If not, I'll get to it at the end. The trial court's dismissing Vic's claim against Funimation for vicarious liability likewise constituted reversible error because he presented clear and specific evidence of a prima facie case that Funimation is vicariously liable for Jamie and Monica's actions. And the trial court dismissing Vic's claim of civil conspiracy is reversible error because the civil conspiracy claim is not subject to the TCPA. This is an argument that they're making. And he nonetheless presented clear and specific evidence of a prima facie case against all appellants. Moreover, the trial court was required to consider Vic's second amended petition, and his failure to do so is reversible error. Additionally, the trial court's finding that appellees satisfied their burden under the TCPA is not supported by the legally or factually sufficient evidence because the trial court considered inadmissible evidence over Vic's objections, which is reversible error. Finally, the trial court's ordering Vic to pay appellees legal fees and sanctions is reversible error. Trial court's October 4th, 2019 order and its final judgment must be reversed and vacated. In this case, remanded back to the trial court for trial. Okay, so this prima facie statement that keeps coming up, a prima facie case is what you have to make to get past TCPA. And that means you have to submit sufficient evidence that is clear and specific that makes a case that on its face, prima facie, lays out each element of each cause of action. Now, I'm not going to go through what each element of each cause of action is, but they're suggesting that they laid out a prima facie case. Now, when you're laying out a prima facie case, all factual discrepancies are resolved in the favor of the non-movement. A lot of words. Vic is the non-movement. The defendants are the movements. They moved for dismissal. Vic did not move for dismissal, so he's the non-movement. So all of the factual disagreements between those have to go in favor of Vic, and anything that Vic asserts as true that remains uncontroverted is assumed to be true for the purpose of creating a prima facie case. It's actually kind of a low bar, and therefore it should be able to be overcome with just some evidence thrown in. Vic's team believes they did that. The defendants obviously will argue that they didn't. But that's where we are right now. Here's the first video about this appeal brief. I will break down each section of this thing in shorter videos in case you don't have time to pop into the 3-hour-long live streams. I know they're kind of daunting. So that's why I'm providing these. If you like them, subscribe, share, like it, all of that fun stuff. Thanks for hanging out with me today, guys. I hope this was informative, and we'll see you very soon. Have a good one. Peace. Peace.